always good to have a couple of lawyers on speed dial.
Especially what we do for a living. John is with Rio and Caraway tackling some top stories this morning.
That's right, guys. Chuck Caraway, Dan Del Rio joining us to talk about some stuff we've seen in the news. Good morning, gentlemen. Thanks for being with us.
Morning.
Okay, so we had the story of that Alaska Airlines flight. Door just flies off in the middle of the flight, and then they start to find, oh, there's some loose bolts on other planes. So the first thing I thought of was, A, there's going to be lawyers involved, but B, who is responsible for this? Who is facing the legal trouble here?
So we've kind of gone over the same thing a couple of times in the past, and what it is that when you have an airplane or a bus or a taxi, you have what's called a common carrier liability. In some instances, liability can be higher when you have like a professional negligence of like a doctor or a lawyer.
Yeah.
Then you have regular negligence, and then you have like a lower echelon of negligence. It's easier to meet, and that's what common carrier is. When you're in one of these vehicles like that, they have to make sure that you're safe. So in this particular case, there's already been a lawsuit that's been brought, two California, two Nevada residents. And what they're doing is they're suing Boeing, the plane company, and they're suing Alaska, which is the owner of the plane. And what they're saying is that it came off the production line, and that they knew that these bolts could have been loose. They have to have notice. And then what they're saying is that through negligent inspection, these bolts came loose, they never noticed it. And then this plug door came off. So that's what they're going after as far as liability is concerned in this particular case.
To boil it down, would it be that they're saying, Boeing, you should have sent out a better plane. Alaska Airlines, you should have caught the problems with the plane.
Yes, on both of those things. And then there was one thing that was alleged in the complaints that said that they kind of had notice of this, and that there was a pressure check thing that was going off from around December 7th to up to when this happened. There was 4 different times. So they're saying, you had reason to know there was something wrong and you didn't find it.
So the first thing the lawyer does is sends them a notice, save all your email, do not delete any emails, we're going to need to see them.
No spoliation of evidence.
As you can see, there's a lot of specialized knowledge in claims like this, and it's actually interesting. Charles has handled one of these before.
Yeah, they're hard.
Yeah, I would imagine so, because you got to prove who knew what when, right?
Yes, and it's a federal claim.
Okay, so another legal issue we saw was that defendant in the court in Las Vegas who quite impressively caught a lot of air going, jumping up to the judge like that. I saw one of the questions I saw from a lot of people online was, because days later she came back to sentence him for the original thing that he was in there for, not for this. Explain the, I guess, recusal, for lack of a better term, how this all works, why she's still in charge of his case.
Okay, so, well, in this particular case, first thing, I don't think you really need a lawyer's expertise in understanding don't attack the judge. I mean, if you're going to do anything, that's one of the more not so smart things that you could possibly do. But in this particular case, the judgment was likely already rendered. She just didn't get the opportunity to tell him what it was. She told him, you know, you're going to be doing prison time in this case, and that's in fact why he attacked her. So she doesn't necessarily need to recuse herself if that judgment was already rendered. If it hadn't been rendered and she had to sit and she had to decide his punishment after that, she likely would, under the rules of professional conduct, have to recuse herself, because now she has a vested interest in it and the fact that he attacked her. And it doesn't matter how calm and, you know, sane that you want to be, you're going to have a little bit of anger and animosity towards somebody that attacks you, and you're probably going to judge them a little bit harsher.
Don't have to name names, but have you guys ever had a client where you're like, please stop doing what you're doing right now?
I have, may have had a client that maybe has attacked a judge before.
Oh my gosh. Wow.
So. Not a judge, I'm sorry, a bailiff. A bailiff.
You're like, wow, you just made my job harder. Okay, another interesting issue is Mickey Mouse, at least early versions, is now part of the public domain, meaning no longer has copyright protection. The first day that happened, January 1st, you saw this video right here, set to some songs that you would not expect. So help us, Dan, get through the legal waters of this. What can we expect to see from the public domain Mickey Mouse?
I mean, it's a very complicated morass. To be honest, Disney has enjoyed the longest copyright protection of any company we know. They've extended it time and time again. These things are generally for set periods of either 7, 10, something like that years. They get extended upon petition. It got to the point where they had extended it so often, there was then an extension done by actual legislation at one point for another 20 years that froze it all. It's been out there for 95 years protected.
Wow.
So the whole idea here with general copyright law is that the inventor of a product is supposed to have a certain period of time to recoup their investment and make a profit. Otherwise, why would anybody go to the effort? Okay? So that's the general theory is, look, you off the bat, okay, say it's 10 years, you're going to go ahead, you're going to be protected for that period of time. The whole idea is recoup, whether you're a pharmaceutical company that's made a new drug, or you're an automotive company that's made a new car, or you're an artist that put together, rendering of Mickey Mouse. The idea is it takes a certain period of time for it to be worth the company's efforts and investment to make their profit back. In this case, Disney kept making the plea that essentially they keep reinvesting into this again and again with the parks, the movies, the ongoing merchandise, the whole thing, so they needed more time. It's finally, after 95 years, the courts have ruled, no, this is public domain, so at this point, it is fair game for Steamboat Willie.
Wow. And of course, Disney's now going to say we have to raise rates at the park because of Dan Del Rio, Chuck Caraway, thank you very much, guys. Appreciate it. Cordy?
Thank you.
Thank you.